So you give the pages to on the compilation. Otherwise, I don't want to.
Here, sir, I'll go through it.
Now, note two more things, Balas, on 17. So first point on 17A is conditions between a section. Number 2, your lordship's judgment. Number 3, there are 2 circulars about criminal law approach and investigation under 17A. One circular is by the High Court of Karnataka.
That is after judgment in JV Ashok.
I'm grateful.
Yes.
So one is that, Balas, at 260 of the paper book. Just note that.
Given that.
And there is one by the central government, a SOP. One second.
Which is the central
First one is 260, just for 15 seconds, just pause it that.
260.
Yes, that is 23rd September 2023.
Volume 2.
Huh? Volume 2.
Petition. Writ petition.
The writ petition, no, not the law, not the law compilation, the main writ petition file.
Page?
No, please. First is 260. I'm on the High Court of Karnataka circular.
260.
Emphasize it is mandatory. Please follow it
No,
strictly.
this is
That's
after
all.
Dr. Ashok's.
That's right. So I'm just pointing out the circular 260 of the paper book. Now the second one is 703, which is the last page document, which my learned friend was saying, on 3rd September 2021. 703.
Yes.
And the last 3 paras of that are relevant, which are paras 2, 3, and 4 at page 704. So as to standardize and operationalize procedures with a view to achieving uniform and effective implementation for prior approval processes, a set of SOPs are hereby conveyed. The SOPs provide for stage-wise processing of information received by a police officer, specify the rank of police officer to seek prior approval under section 17A. Considering the proposal under 17A by the appropriate government or authority, laying down a single window. Well, if the condition because the section is not looked at, so where is the question of doing all this? All administrative authorities, including ministries and departments of central and state governments and IAs, investigating agencies, are requested to take note of the SOP as appended herewith, bring to the notice of all concerned, etc., etc. So I've done 3 points. Natural justice is clear. The first point was name of Mr. Abraham. Actual order has 2 more. Those 2 more never supplied to me. The order is based on those 2 also. Second point is he does not discuss or give any reason. Third point is 17A. Fourth point is 218. Can you turn to 218? What is the point here, Malas? At page 47, the learned governor grants an order which invokes 218 of the Sanhita. At page 47.
Yes, I am there.
Right, Malas? Now, Lordship knows in pari materia 2197 and all that. Now, the language of 218 itself makes it clear that it has to be offense specific, ingredient specific.
Yes.
Resistance to taking of property by lawful authority of a public servant. Whoever offers any resistance to taking of any property by the lawful authority of any public servant, knowing or having reason to believe that he is such public servant. So knowledge is important, mens rea. Such shall be punished with either description. But suppose I go to somebody and say, you're guilty of 218, you're guilty of 218. 218 is not an end in itself, you have to show what 218, what ingredient, what offense, how. How is important. See page 47. Lordship find nothing. Page 47 is nothing. It says exactly what I'm saying. 218. There may be other points I'm not arguing now on that point that 218 came now. This offense relates to when.
Since
But that's all right. I'm not, your Lordship will have to see whether it applies back or
it's
not.
taught after BNSS and being granted, it is only BNSS.
I am not even arguing that for the time being.
Yes,
I don't want to get into that. Now, there's 2 more things that I'm done. One is, the larger issue of selectivity of these 4 other complaints, which my lord has noted that 1 page of the cabinet
That I
decision.
have seen. Let them all file their
Names are given.
objections.
Names are given there. Details
No.
are given.
Let the respondents file their objections if they want to.
That's right. If they say that, look, for this reason, I could not decide a 2021 complaint, but I decided yours on the
So
same day.
that let even the
So, Malas, I am saying,
SG is representing the
My
governor.
instructions are there are no sanctions pending.
let me end.
Yes.
Let me just end. Please allow me to finish. Malas, one thing which is larger issue, not today, but Lordship should know the flavor of it. just turn to 155 para number of Navam Rebia. I'll be very brief because
155,
para number. Now I hope we get it correct this time.
page
869. Turning it and saying it.
para 155.
Now, 155, that your lordship's 1027.
Summarize our conclusions.
Right. Firstly, Constitutional Bench is summarizing the measure of the discretionary power of the governor. So there's no point, my learned friend, just was flushing it aside by saying, oh, it's a 10th schedule case. It's a 10th schedule case which arose in the context of an intersection with the governor. The governor tried to interfere. The court said, you stay put within 163. Directly arose. So my learned friends, fellows,
No,
and
here sanction has to be accorded by the governor only.
correct.
No,
We are not on the
being
governor.
found by the advice of the Council of Ministers
Where
would not.
where the chief minister is no party of the decision-making process.
That will consider.
That's
Yes.
Now let's just see. Firstly, I think this point for a minute, I'm assuming against myself. I'm just
Yes.
putting it, because I opened with the other point.
Yes.
But I'm just putting it for 2 minutes and ending on that. The measure of the discretionary power of the governor is limited to the scope under 163(1). Now, 163(1) doesn't say that you can say blanket the entire cabinet is disabled because the chief minister is involved and he appointed you all. You can't say that. That's too general. Then, Malas, all the cases your lordship has of conflict of interest are where I am in some way directly myself deciding my case. It's not this case. Then, Malas, secondly, under 163, the discretionary power extends to situation where a constitutional provision expressly requires the governor to act in his own discretion. Expressly. None. Thirdly, the governor can additionally discharge functions in his own discretion where such intent emerges from a legitimate interpretation of the provisions concerned, and the same cannot be construed otherwise. Fourthly, in situations where this court has declared, sometimes a lordship says you shall decide. That is not this case. And lastly, fifthly, or 163(2), final and beyond the scope of judicial review, answer no. Answer no. Now, Malas, two things I've done here. I have read to your lordship the last word of a constitution bench. I have read to your lordship 163, which is directly relevant to the governor's powers on the larger issue, not argument. Just one thing and I end, Malas. Just to tell your lordship why my learned friends, instructions are wrong on this. Note this, that MP police judgment, which is in your lordship's file at page.
Yes.
Just note these paras. This lordship may note because it will be difficult to
242.
find out. Yes.
No, 262.
But just note these paras.
Yes, that's all right.
No, I'm sorry. My apologies. I meant something else. The paras of Navam Rebia, which deal with MP establishment, those paras.
So which is that?
Para 116. Lordship will note the para. Lordship will see it later on because it's not being argued now.
Yes.
So clearly, Navam Rebia will govern, not MP. The governor cites only MP. Now see those paras. 116, 118, and 118 may be ticked by lordships in particular. I'm emphasizing it. 128.
This is exactly the point. There was a case where governor had to act or was required to act on the aid and advice of the Council of Ministers because he is not acting on his own. Now here is a case where sanction has to be accorded by him acting on his own with application of mind is imperative. Yes, that you may say.
Very well, I will.
According this judgment may not be.
No,
prima
why
facie.
not? My lord, therefore I'm only saying Navam Rebia and MP will be considered at final hearing in some form as to how much of
That
MP
will-
remains. That's all I'm saying. Let me not argue it now.
Because what was imperative in there and imperativeness
Yes.
here are totally different.
Now, well,
Play
I
the
bow
role of
down.
the governor.
I bow down to that.
Yes.
Well, lastly, two things. First and foremost, fellas, the governor is a person who has spoken in his order. If I don't make him a formal party, we make him a tribunals a party frequently, but they don't necessarily, he cannot have an interest in your lordship granting me or not granting me interim protection.
That will.
No, I'm just
answer.
pointing out, fellas,
Yes.
because it's easy that I'm a governor, I've come, therefore give me. I'm saying he may be there. He may come and deal with it, but he can't be personally interested in expanding, rewriting, or supporting his order beyond the interim stay which one is seeking today. Number one. Number two, and it would be very odd for a governor to do that. It will validate my point. Number two, it is clear that the matter is before the court tomorrow. Now, you will have cognizance, you will have pre-cognizance and post-cognizance actions. The whole idea is to then start a process to undermine and destabilize the government. Number three, it is also constitutional law, law and politics are intertwined. We are not, we don't live in some ivory tower, cloud cuckoo land. Your lordship is not in a, that a storm is coming, so I'm a ostrich, so I'll put my head in the sand. That's not the way judges function. So immediately then, a whole process starts clamoring. There is, of course, nothing in law short of a conviction which affects your resignation. But the idea is, why start a process which is on the face of it, 1992, 2024, today you go to the governor same day issues show cause. Within 2 weeks, we are less than, let's say, 1 month. And he must, your lordship, on what balance of convenience must there not be a status quo ante as of prior to the order of the governor's order? On what basis? If heavens have not fallen from then to now, and on what basis will the 1 day before the order of the governor not be a valid balancing of equities, not be a valid irreversible consequence test, not be a valid balance of convenience test? And governor, just because of stature, should in fact keep away more aloof. He should not be saying why no stay.
Anybody has to reply, we'll see.
Lord, only 5 minutes, my lord, because I have yet to go through it, my lord, but I have
Go
an
through the papers,
answer.
file your objections.
My lord,
All of
I
the-
have
who are
only-
respondents, let them come up with objections.
Yes, certainly, my lord. My lord, only
Detailed objections.
few facts, my lord.
Yes, yes.
Without going into the merits, my lord, because my
Yes.
learned friend said something, and we have an answer, my lord, in law of everything, my lord. I represent the governor, the office of the governor, and therefore, my lord, I do not have the luxury of, my lord, using adjectives like friendly governor, etc., because it would not be in good taste. Suppose I also start saying subservient cabinet or a corrupt chief minister, doesn't look good, because all are constitutional functionaries, and irrespective of the party position in the petition, whether we are petitioner or respondent, we must respect the constitutional office. Lord, the 3 questions, my lord, which I'll have to answer, my lord, first would be the power of the governor in granting sanction under 17A vis-a-vis the cabinet decision. I'll be able to show para to para, page to page, cabinet decision and the pages of the petition, verbatim saying, if cabinet decision is first, then it's okay. Then, my lord, the person who has drafted the petition is guilty of plagiarism. But if the draftsman is same, then the cabinet is guilty of non-application of mine. But that's, my lord, on facts. In law, MP, my lord, governs the field, and MP judgment, my lord, clearly only, my lord, 1 paragraph, if your lordship permits me to cite, my lord, concludes the issue, my lord, so far as the constitutional position is concerned. My lord, please come to, my lord, that MP judgment. I don't have, my lord, my learned friend's compilation, but MP judgment, para 14.
I've not even argued for time being, I've not even argued. I started, I left it there.
Para 14. Mr.
Yes.
Dr. Singhvi, you argued for 2 hours. Give me few minutes.
Yes, sir.
I'll confine to the constitution and not any spicy expressions for media. Lord, please see para 14.
Yes, sir.
As has been mentioned above, your lordship gets, my lord.
In
Lord, MP Special Police Establishment versus State of
That's-
MP.
225.
Yes, my lord, it's a constitution bench judgment where precise question was the power or responsibility of the governor while granting sanction, whether he is bound by the cabinet decision or not, whether aid and advice of the cabinet would be binding on the governor or not. Para 14 starts, my lord. I am not reading the entire judgment at this stage. My lord, I'll assist your lordship, my lord.
Yes.
But your lordship may not find that judgment.
Lord, 14, my lord.
Where do I-
Copy, you can give a copy. My learned friend is giving a copy.
14 and 19, my lord, 2 paragraphs. My lord, that summarizes the law. And my lord, whoever has prepared the cabinet note, my lord, has relied upon this, unfortunately, forgetting that their counsel would come and dispute that by citing Nabam Rabia, which is completely irrelevant for present case. 14, your lordship gets, my lord?
Yes, I am there, sir.
As has been mentioned above, the division bench had noted this case. The division bench, however, held that even though this principle may apply to the case of chief minister, it cannot apply to a case where ministers are sought to be prosecuted. We are unable to appreciate the subtle distinction sought to be made by the division bench. The question in such cases would not be whether they would be biased. The question would be whether there is a reasonable ground for believing that there is likelihood of apparent bias. Actual bias only would lead to automatic disqualification where the decision maker is shown to have an interest in the outcome of the case. Principle of real likelihood of bias has now taken a tilt of real danger of bias and suspicion of bias. Now please come to my lord 19. They are saying
Yes, sir.
when the cabinet is deciding about the minister or a chief minister, what will be the contours of the power of the governor?
Yes.
Where are 19, my lord?
Yes, sir.
Article 163 has been extracted above, undoubtedly in a matter of grant of sanction to prosecute. Governor is normally required to act on aid and advice of the Council of Ministers and not in his discretion. However, an exception may arise while considering grant of sanction to prosecute a chief minister or a minister where, as a matter of propriety, the governor may have to act in his own discretion. Similar would be the situation if the Council of Ministers disables itself or disentitles itself. Mr. So-and-so on behalf of ministers submitted that the case of chief minister would be completely different from the ministers. He submitted, my lord, not relevant. My lord, court says no. It applies to both, and there would be an apparent likelihood of bias if the cabinet decides, because the cabinet is appointed on the aid and advice of the chief minister by the governor. And para 32, my lord, of this judgment. On these facts and circumstances, the governor cannot act in his own discretion. There would be a complete background of rule of law, etc., etc. There was material before him, prima facie, etc. The second question, which I'll deal with, my learned friend's contention that the governor has not dealt with, parawise or otherwise, the decision taken by the cabinet note. There are twofold answers. Answer on facts. The cabinet, the governor has taken a view that the cabinet's decision is not binding on me based upon the principle of law laid down in the 5 judges case. And therefore, there is no question for me to examine whether it is right on merits or not, because it has no jurisdiction. Second, and without prejudice to the first, there are judgments to the effect that even while acting on the aid and advice, the governor cannot sit in appeal over the decision. He is not an appellate authority who will go into the matter. I'm sorry. Go into the merits of the case. Your lordship's judgments on only police can seek approval and not that helps, that assists your lordships again, for the facts of the case. But it's a reasoned order passed on file. I'll place it on record, and whatever constitutional position, I'll assist your lordships.
All right.
I would request, any date, because once, the governor, who is a constitutional functionary, has granted sanction, injunction of any kind, whether direct or indirect, by another constitutional body
true,
may be avoided. That's all.
The submission we have to hear and readings have to get complete. The
Yes,
submission
yes.
is that the matter is tomorrow. This should not be rendered fait accompli by any action taken by the concerned court.
But unfortunately, in our legal
all.
system, nothing happens in a day in a court of law. My learned friend can,
Act on the sanction, because they can't act.
Yeah, that's right.
because my lord, indirectly also, the lordships
We'll
would
post
be
it day after tomorrow or Thursday, whichever day you
Thursday,
want.
my lord, Thursday,
Thursday.
my lord.
We'll
file
post it Thursday.
day after.
Let not the court proceed further till Thursday.
That's all.
But they can seek time. I mean, there are ways and ways, doctor.
no,
We know.
Let it not.
No, the complainants are here, but the complainants are here.
Complainants are here.
Not just
I-
deferring the, staying the proceedings. but
I'm not-
no,
I'm
just-
not granting anything of that kind, wait.
This
yes.
is not an ego fight, but your lordship is only saying not till Thursday. It's not that, well, we have
No,
to.
no, it's not an ego fight. The question of
My
constitution.
learned friend is not going to be, well, as part of the proceedings there.
I am not going to
It's
be.
a-
Yeah.
No, no,
No, I understand. I understand, Dr. Singh. We are-
SG sir.
92 to 22 proceedings in
No, that
Thursday.
I will, everything I will answer, that's a different thing. SG sir, I just wanted, see, day after, tomorrow, if the proceeding is there and he would proceed to pass some order, then these proceedings should not, they may not become,
Infructuous.
Take a-
infructuous,
I
but
bow
why
down.
FA
I'm not,
accompli?
I'm for a second not, my lord, either supporting or opposing, my lord, the stay, because
why,
it's
sir.
for the complainant to do, but
No, because we are
Govern-
hearing the matter, hearing is
No,
whole
no,
house.
certainly, but
Yes.
lord, I have a suggestion to make. Lord, the governor having
No,
granted,
whatever
the
matter is tomorrow.
You are completely
Lord,
confused.
governor having granted sanction tomorrow, any-
No,
Ma'am,
I'm
please
hearing it. See,
always-
Superior Court, 1 minute, yes.
ma'am, if you don't mind,
Well, I don't understand why the SG is arguing on the interim stays.
no,
Your
I'm
lordship,
not
well, as-
arguing on
just to
interim.
explain
He's-
to-
No, he fairly said that he's
I'm-
neither
I'm-
against nor for.
I'm
I
neither
hope, well,
against
that
nor.
sentiment is maintained. Well,
Lord,
That is- That's
my lord,
not, yes. sir.
principally,
He is not-
my lord, constitutionally, once
Yes, yes.
the governor's sanction under challenge, based upon which some proceedings are on, my lord, another constitutional body, namely the court, would be very wary. I'm not saying there is no
and
jurisdiction.
well as the High
Say
Court, the
anything.
superior body
Only a minute,
sees
Dr.
of the
Singh. We
matter.
now,